You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, sir.
Okay.
Thank you, Judge. Judge, law enforcement officers were dispatched to a disturbance call in Harris County, Texas, and made contact with a complaining witness who stated that on April 28, 2025, she observed a prior resident, the defendant, cause damage to the apartment complex after a breakup with a significant other. The complaining witness stated that the defendant broke 3 flower pots and damaged 3 trash cans for a total of $405 worth of damage. On April 29th, the defendant came to the leasing office and demanded property that was left. The complaining witness asked the defendant if he was the one that caused the damage. The defendant stated he was not. Complaining witness and a witness then tried to get the defendant to leave due to him causing a disturbance. Defendant pushed his way through complaining witness and a witness. A law enforcement officer on scene serving civil papers attempted to detain the defendant. The defendant was able to get away and run from that law enforcement officer. The defendant was later detained when other law enforcement officers arrived on scene.
So the mischief, it's at an apartment,
That's correct, Your Honor.
his apartment?
I believe he was a prior resident of the apartments, Your Honor, and the property belonged to the apartment complex.
And that was my question this morning, Your Honor. I haven't stayed in an apartment in a long time, but typically apartment complexes don't give their property at a residence specific apartment complex.
You mean furnished?
Furniture, it's flower pots. I mean, why would an apartment complex have their flower pots out in front of a resident's apartment?
Okay, what all was allegedly broken again?
3 flower pots and 3 trash cans, Your Honor.
Are you saying it belongs to him? What are you saying?
I believe it belongs to him or to the partner, the former partner, the leasees, the people that lease the actual
Because if
premises.
it belongs to the other person, then
3 trash cans were $35 each. They're placed outside for residents to use for trash bags on all 3 levels of Building 8, causing the property to.
so it's like, it must be, cans that officers put out there in case anyone needs to put trash in or whatnot. You know what I mean?
Yes, sir.
As far as the interference is concerned, that I may have a problem with,
I don't see how that was interference.
because what would they possibly put him in custody for?
So, Your Honor, just to clarify, I'm not, what the DIMS say, and they go to the great lengths to explain this, is that there was a deputy there who was serving some sort of civil paper.
Sure.
And that he had to stop serving the civil papers to go
To chase him.
detain the defendant, because the defendant, there was a disturbance in the leasing office. And at some point during that disturbance, the defendant got away from the deputy who was serving the civil papers.
Correct.
It's not really clear from the information. Is the serving the civil papers and having to stop that duty to go detain the defendant, or is it the defendant getting away from the deputy, if that's what the basis for the interference is?
And that's correct, Your Honor. Richard and I spoke about that this morning.
So you don't think there's PC on the interference?
I don't think there's PC on the interference, honestly, either way. If he's trying to serve papers,
I think I agree with you on the interference,
yes, Your Honor.
but I think that there's PC to go forward on the criminal mischief.
Yes, Your Honor.
No?
I'll dump the interference.
So I'm going to find no probable cause to go forward on the interference. I don't think that they had a reason to, have you in custody or for you to interfere with.
Yes, sir.
I will find that there's probable cause to go forward on the criminal mischief. Is he staying there now or is he gone?
No, Your Honor. I think both individuals have moved away from the apartment
Okay,
complex.
so Mr. Eichelberger, the only thing I'm going to ask you now, or I'm going to order you, is not to go back to this place, not to have contact with the complaining witness.
I
Do you
understand.
understand?
Yes, sir.
I'm also ordering you as a condition of your bond, not to be in possession of weapons as well. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Brock and he'll tell you if and when you have to come back to court. Just stay out of trouble. Don't pick up any new cases. I don't want to have to put you in jail. You
I understand.
become a danger to my community. It's not going to go well for you. You understand?
Yes, sir.
Okay. So for now, I'll have you go to Victoria, sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it, and then after that, you're free to go.
All right, thank you.
Thank you, Your Honor. May I be excused?
Yes, sir.
Thank you.
Marco, do you have an arrangement?
No, you're still in arraignment? All right.
Yeah, I don't think that there's much, but
All right, Judge, page 10, Gonzalez, come on up.
My left thumb.
all right. Good morning, Ms. Gonzalez.
Good morning.
Ma'am, you're charged with terroristic threat of a family or a household member. That kicks it up to a Class A misdemeanor, so you were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Judge, on March 20th, 2024 in Harris County, Texas, officers responded to a terroristic threat call. The complaining witness and the defendant are sisters, and complaining witness stated the defendant is not allowed to go into a residence. The complaining witness's son mistakenly let the defendant and her husband in, and they drank a beer. The complaining witness texted the defendant about her being in the residence, and the defendant responded with threatening messages that stated the defendant will slap CW and show up at, slap the complaining witness and show up at the complaining witness's job. The complaining witness stated she feared for her safety.
What the hell does that mean? It's got to be serious bodily injury, man. Or
Yes, Judge.
are we putting everybody in jail now for whatever?
Judge, that's really all I have.
Statute.
Sure.
Okay, what was it said exactly again?
Judge, the message that the defendant sent to complaining witness states, exactly. Bitch, don't talk out your ass because I will go to your house and slap you in front of your family. I'll even come to your job.
That's not imminent serious bodily injury. Come on. All right, I'm gonna find no probable cause, ma'am. As the old adage says, sticks and stones, right? Words will never hurt. They actually can. You have to be careful what you say, who you say it to, because it could end you, you could end up in hot water. I'm gonna find no probable cause in this case. The idea also is that if you don't have a good relationship with someone, it's probably best not to just inject yourself repeatedly in there because you're asking for trouble,
Right.
I mean, you now know. All right, man, please, just be careful, all right?
Your Honor, I'm filing dismissal.
Thanks. All right, ma'am, your case is being dismissed. If you want to copy the dismissal, you're free to wait. Otherwise, you're free to go. Okay.
All right, Judge, next is page 12. Guzman, come on up.
You are here, Guzman? Mr. Guzman, you're charged with two cases. You're charged with assault of a family member. You're also charged with driving while intoxicated. On the assault case, you're facing up to a year in jail and or a $4,000 fine. And on the DWI, you're facing up to jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Thank you, Your Honor. On April 29th, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle with an expired registration and initiated a traffic stop. The law enforcement officer made contact with the defendant driver and observed a strong odor of alcoholic beverage. The defendant admitted that he had an open container of an alcoholic beverage in the back seat and admitted to drinking 2 to 3 beers.
While driving?
It's not clear as to when the drinking occurred. I'll check further in the dim summary. The law enforcement officer found an open 16-ounce Miller Lite can, half empty and cold to the touch under the driver's seat. The law enforcement officer observed the defendant to have unbalanced and a strong odor of alcoholic beverage. Standard field sobriety tests were conducted. A 4 out of 6 on the HGN, a 1 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The defendant consented to providing a breath sample and blew a .112 and a .111.
Okay, now we have an assault, right?
Yes, sir, that one is open. And we need.
Whoa. Whoa, so that was an open case.
Listen, Judge? That one was a open warrant for a few months. A non-arrest.
Okay, do you mind reading me what happened on the assault, please?
Absolutely, Your Honor. On March 1st, 2025, in Harris County, Texas, officers were dispatched to a family assault. A law enforcement officer met with the complaining witness who stated that the defendant is her ex-boyfriend. The complaining witness stated that they got into an argument over the complaining witness's inability to make him a sandwich. The complaining witness tried to stop the defendant from leaving, but the defendant closed the door on her hand. Later, the complaining witness was holding her child when the defendant bit her, causing bite marks and a bruise. The complaining witness stated that the defendant has assaulted her before, but she never reported it.
Mr. Guzman, I'm going to find that there's probable cause to go forward with your case on both cases. I am ordering you can you look to see any prior DWIs, please?
Yes, Judge.
I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I would think that it's freaking elementary that you're not to have alcohol in the car while you are driving. I am now taking away your privilege to drive. You are not allowed to drive for any reason. I don't care where you have to go. I don't care what you have to do. I don't care that you have to work. I don't care if there's a burning building and you have to save 50 kittens. You get into a car and drive. You will be signing an affidavit. This is a promise you're making to me that you're not going to drive. If you do, every single time that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand me? I'm also finding that there's probable cause to go forward on your assault case, and I'm barring you having any contact with this complaining witness. There is a protective order that has been issued in this case. Get to know it, because if you do something to violate the protective order, the state can and probably will file additional charges against you, a violation of protective order, and that is the capital murder of misdemeanors. Mr. Guzman, I'm going to protect every single person in this county, whether they're on the street, whether they're on foot, whether they're on the house. And if you become a danger to my community, I only have one place for you. And I don't know who you have in this life, but if I put your bond at 10 to 20,000, if you don't have anyone to pay it, you will be stuck like Chuck in there until these cases are over with. Do you understand?
Yes, ma'am.
Any prerogative, yes?
No, Your Honor.
Okay. Mr. Guzman, do you have the ability to hire a lawyer? I can have you fill out an application. I need to know everything about you. How much money you have coming in, what you're doing, what kind of car you have, any kind of retirement. I need to know everything about you, and then we'll take a look to see whether you qualify. Don't be a danger. Do you understand?
Yes, sir.
You get no more warnings. All right, Deputy Miranda.
In 1 second. All right, go ahead, Ms. Owen. Judge, we have one more.
Okay,
We're on page. We're in 22 and 23. Rooker. Guzman. Rooker is set for arraignment. Someone was attached, but from a long time ago.
I remember Mr. Rooker. So, I mean, where is he?
Rooker.
Come up, sir. Take a seat for me in the jury box. You know what? I don't, have you reached out to her? This case is 435 days old, and I know that she has a lot of history with him. I'm ready to put these babies to bed. So appointing another lawyer, it's going to take another month or two, and I don't want to do that. So, who are you guys?
We're his parents.
Parents? Okay.
Can we talk?
Not yet. Let me get a lawyer. I know. We're going to try to get a hold of her.
For this month, do you want to do random drug testing
On who?
on Guzman?
But let's see,
CPWI.
let's see.
There's coming around.
Judge, that's it for now.
Okay.
That's all. Do I need to vote for 337?
No, we can do time.
I think, let me see. Well, that's maybe that's one. Yeah. Oh, that's just was evidence.
I'm not. I'm just not gonna mess it up. If you wanna go to the, if you wanna go home, 37. So, no, I mean, my stuff.
Okay.
If you wanna, if you have to check in with 37, I can see.
All right, let's talk about that. This hearing was a whirlwind of contrasts, quick dismissals, intense admonishments, and moments of levity, all expertly balanced by Judge Fleischer. Things started with a case of criminal mischief, where Fleischer cut through a muddled narrative about flower pots and trash cans with a sharp analysis of probable cause, dismissing an interference charge outright while still imposing clear bond conditions. It was a precise example of his approach, fairness rooted in logic. Then came a fascinating moment when a terroristic threat case was dismissed, with Fleischer invoking the sticks and stones adage while reminding the defendant that words still carry weight. It was equal parts legal reasoning and practical wisdom. The tone shifted dramatically with Mr. Guzman's two charges, driving while intoxicated and assault of a family member, where Fleischer delivered a blistering but controlled lecture. He stripped Guzman of driving privileges entirely, spelling out consequences with striking imagery. I don't care if there's a burning building and you have to save 50 kittens. You get in a car, you're going to jail. He also underscored the seriousness of violating protective orders, labeling them the capital offense of misdemeanors, and made it crystal clear that Guzman's leash with the court was very short. The judge's energy oscillated between humor and firmness, demonstrating a courtroom style that educates and enforces in equal measure. Even the brief exchange about an old harassment case showed Fleischer's pragmatic side. He resisted delays and aimed to put these babies to bed, prioritizing efficiency without sacrificing care. Throughout the docket, his interaction with attorneys and defendants struck a balance of professionalism and personality. He managed to lighten the mood while maintaining firm control. This was classic Fleischer, efficient, unflinching, and deeply protective of the community. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.